Microphone check. Microphone check. Okay, welcome to the first live stream for Nizz Realty Inc. This is more of a test stream to see how the streaming platform works and to go over a couple things, make sure the audio is fine. We're going to try to go over a contract and see how the video footage looks, and if anyone watches this, feel free to let me know how it all turns out. So for right now, I'm just going to start going through this contract, and if anyone in the chat comes in and has any questions about what I'm doing or how to fill this out, I'll be happy to answer the questions. So I'm going to keep an eye on the chat, and for now, I'm just going to start going over this exclusive right to lease listing agreement. This seems to be one of the most popular videos that I've put up, and also a lot of agents contact me about. So we're going to start filling this out, talking about a couple of different scenarios, and take it from there. So the exclusive right to lease listing agreement. The first thing to talk about this listing agreement is this is the recommended listing agreement you use when you're going to be representing an owner, the landlord, and you're going to be putting the listing, you're going to be advertising it for rent pretty much. So I always recommend to use exclusive right contracts, because without the exclusive right to lease or exclusive right to sale, if you're doing a sale, then you're not entitled to the commission under any and all circumstances. And it's just my personal professional opinion that if I'm going to take any listing, I'm due my commission regardless of who sells the property, because I'm investing money and time into advertising the property, and that's just personally how I operate and what I suggest. So I always go with the exclusive right to lease when rentals, or exclusive right of sale for when you're doing a sale, so that your commission is due. So the exclusive right to lease listing agreement is where you I recommend you begin when you're doing a listing contract representing a landlord or an owner, and you're looking for a tenant for the property for your client, the landlord. So filling out this lease agreement to list the property, it's fairly simple in the beginning. You just put the owner's name. So let's just say the owner today is Billy Bob. Billy Bob is going to be the owner of this property today, just as a placeholder. Now for the second line, I've seen a couple of mistakes here from time to time. A lot of times the agent will put their name here, which is not what you're supposed to put. If you're an agent working for a company, where it says broker here, as you can see here on the right, broker, you're supposed to put your brokerage name here. Now, when I was working as an agent, this is how I recommend you put it. You don't have to put it this way. Most of the time, you're just supposed to put the company name here, but how I like to recommend you fill it out is you put your company name. So let's assume you're an agent of Nizz Realty Inc. You put the company name there, and then what I like to do is I like to put some parentheses and then put my name as the listing agent here. So let's say let's say an agent name is John Doe. You put as listing agent, listing realtor, whatever you prefer, and so for listing associate, just to have your name on the contract. And of course, you'll sign the contract at the end, so you know you're going to have your signature authorizing this and being the listing representative. But I always like to put my name there. It's just something of my personal opinion and preference. But you know, really, you're just supposed to put the company name there. But if you want my professional advice, that's how I recommend writing it. Is you just put your name as listing associate, listing agent alongside your company name, just to specify that you are the listing representative for this particular listing, so there's no discrepancies. Now the next thing, of course, you want to put the date. So let's say the date is beginning today, which is the 1st of June 2022. Now if you're going to do a 1-year contract and it shouldn't exceed any longer than a year, you could go shorter than that, 3 months, 6 months if you'd like. But if you're going to be doing the maximum term, which is a year in the state of Florida, you shouldn't do contracts any longer than a year. After the yearly contract expires, you should re-sign a new contract. So what you would do here is a lot of the mistakes that I see made is the agent will put June 1st of 2023 the next year. This is actually incorrect. This is not how you're supposed to write it for the 1-year contract. What you're supposed to do is you're supposed to do it 1 day behind. That is the correct way to do it. So what you'll do is you'll put the 31st of May 2023. You always go 1 day backwards. So if this contract began on the 31st of May, it should end on the 30th of May of next year for a 1-year term. Similar, if you did a contract for, let's say, June 20th, and you're doing a year contract, it should end on June 19th the following year. It's always 1 day behind because it ends at 11:59 p.m. So you always go 1 day backwards. So once again, to re-clarify, this contract's beginning on the 1st of June 2022. That means that it's going to expire for a year contract on the 31st of May 2023. So that's how you would fill that out. I know it's kind of can be a simple thing, but this is the proper way to do it. Now, moving on next, street address. Just put the property address here. Keep it very simple. 123 Happy Street, Miami, Florida. We'll just put that as a placeholder. It's very simple. Put the full property address here. Another thing I've seen mistakes made by agents, I don't know why, but you know, it's a mistake, you shouldn't do it, is put the full property address. I've seen agents write no zip code. I've seen agents write no city, no state. I've even seen properties written like this where it just says just the address. There's no city written, there's no state, there's no zip code. Don't do that. That's not the proper way to write the address. You shouldn't be writing the address just as a simple, you know, a street name and a street number. You can't be excluding the city name or the state. Write the full thing. I know it sounds silly and maybe you've never done this before or couldn't imagine it, but I've seen this done, so please, the proper way is to write the full address. Write the city, write the state, write this full zip code. Now the next thing you would do here is the legal description. The legal description can be very long. If you could fit it into here, you know, you could just copy and paste it and put it into here. Most of the time, the legal description is extremely large, so I'd recommend if you can't fit it all here, usually what you could do is you could write something like C Exhibit A, something like that, and then you could create a separate Word document, entitle it Exhibit A, and you could just write the legal description there. You know, because sometimes the legal description can be like over a page long. Some of them, depending on the property, are very massive. So you just want to write up a separate Exhibit A, and you could attach it with this listing contract as an additional addendum, and that could be where your legal description is written, and just have everyone initial or sign that exhibit. Also, sometimes there's additional terms at the bottom of the Additional clauses, no, you don't really want to write it in there. So I'd recommend writing it as an Exhibit A. If the legal description is too big, and you could have everyone initial or sign that exhibit and attach it as an addendum to this listing contract. So that's something to help you out if you can't fit the legal description in this small line right here, because sometimes the legal description is big. Now the personal property, this is where you'd put, refrigerator, freezer, dishwasher, washer, dryer, microwave, maybe a toaster oven. You'd put that here. Sometimes if you're doing a rental and the rental is furnished, maybe it's a fully furnished unit, what you could do is, once again, do something like C Exhibit B, and you can attach an inventory list. So you could write up a separate document, Word document, Exhibit B, and it basically could be an inventory list, which is just a full inventory list of, let's say you have like vacuum cleaners, toaster oven, utensils, kitchen utensils, a barbecue, plates, knives, forks, food processors, a smoothie machine. It could be anything. You could just write up a whole separate exhibit. You could take pictures of everything and make a whole inventory list. But this is for like furnished properties. If it's just like a vacant unit and you just have the standard appliances, you could just write it here and just write refrigerator, freezer, dishwasher, washer, dryer, if that's included. And you could usually fit that in this little tiny paragraph here with those 5, 6 appliances you're putting there. But if it's a huge inventory list and you have like couches, beds, maybe sheets, or desks, computers maybe, or something that's there, TVs, remote controls, you could put it here as a separate exhibit, write an inventory list, take pictures of everything, and attach it as an addendum to this particular contract. And you also want to probably do that for your lease contract when you do find a tenant. So for right now, we'll say see Exhibit B, and we'll leave it at that, and we'll move on to the next part of this listing agreement. Occupancy. So this is basically discussing, is the property occupied by a tenant? Is it occupied by the landlord? If so, is there a lease on the contract? When does the lease expire? So if there's a current tenant in the property, or if the landlord occupies the premises, you would disclose that. You could write is occupied by landlord. You could leave it at that. If the landlord lives in the property and will be moving out by the time the tenant is going to be moving in, or a new tenant that you find, or if there's no one there, you just uncheck these, and you could just check this first one right here. It's not currently occupied. If there's a tenant in the property, you check the tenant, and whenever the lease is expiring, you put it here. So for this particular example, let's just say that it's not currently occupied and there's no tenant in the property. But if you have a tenant in the property, you'll mark it here in this particular paragraph, Part C, and you'll write when the lease expires. Simple enough. The next paragraph we're going to discuss here is the rental rate and terms. The rental rate and terms here is basically how much the rent is and when it's due in installments, monthly, weekly, yearly. If you're doing like a vacation, seasonal rentals, you could check mark the weekly. Maybe you're charging, the landlord's looking for $500 a week for a seasonal rental. It could be a furnished unit and so forth. So that's what you would fill it out there. Similar if it's most of the time a standard monthly rent. Let's say it's $2,000 a month. You could put that there. Sometimes it's yearly, so it's paid annually, and we also have the seasonally here. If you're doing a seasonal rental, where it runs from, you put the dates there. For the particular example in this video, I'm going to leave it at a monthly because that's usually the most common rental that's done, is the installments are paid on a monthly basis, and it's like you see here $2,000 a month, but depends on the unique situation and listed contract you have. You could have the installments paid annually. I rarely see anyone pay the full year up front, but it does happen. I've seen it from time to time where the full rent amount can be paid up front. someone just pays $24,000 for the full year up front. And I've definitely seen weekly for seasonal things where if someone's doing like an Airbnb type of situation, but not exactly, they'll charge weekly, $500 a week, $800 a week, something like that for a seasonal or weekly rental. So for now, we'll just leave it at $2,000. In the next paragraph here, it says specify any services or fees such as water, garbage, association dues, etc. That's what you would put here. So maybe the condo unit you're renting and the water is included in the association dues. So you could say the water is included here. If there are association dues and the tenant's not paying for that, maybe it's included already in the monthly rent, then you could write that association dues are included. And anything else you put here. Maybe there's valet trash, garbage removal, perhaps there's a garbage truck that comes by and picks up the garbage, and you could put that all here. If there's cable included in the rent, maybe the community offers basic cable or internet, you could include that here so that it's specified that the tenant doesn't need to pay extra for that. It is included, and if they want to get something else additional, they can. So you just fill that here in this paragraph. It's fairly simple. Advance rents, deposits, and fees. This is the next paragraph. Most of the time, in most situations, it's going to be held by the owner. I've rarely seen where the broker, I mean, it does happen where the broker or a broker is beholden this amount, but most of the time I recommend that you have the owner hold the advance rent or any type of deposits and so forth. They can do that as long as they're respecting and following the law and how they should be holding deposits, and the advance rent and so forth. And you'll check mark this paragraph. Most of the time it's in a non-interest bearing account, but that's not always the case. It can be in an interest bearing account. And if you're going to do the interest bearing account, I suggest you talk to your broker and so forth about where the interest bearing account's being held. If your broker has an interest bearing account, and who's to receive what amount of the interest. Most of the time it's usually the broker that receives the full amount, but that's not always the case either. The interest can be split between the parties. Most of the time I just leave it up to the owner. Don't get involved as a broker. Let the owner hold the deposits and so forth. And if the owner is going to have an interest bearing account, then you can fill this out accordingly in one of these other two paragraphs, for who's to receive the interest. Is it to be split? Is it to go directly to the broker? So you can pick one of these second boxes. But to keep it simple, let's just say it's a non-interest bearing account and the landlord that is holding all of the funds, to keep it simple on you, the realtor, and the broker. So these next paragraphs discuss the advance rent. This could be used for first, last, and security. Maybe you want the last month's rent of $2,000. So you could write the advance rent of an additional $2,000, a security deposit, however much the landlord's suggesting. In my professional opinion, depending on the property, I always like to recommend that for the security deposit, you advise your client to hold the landlord to get a double or triple security deposit. What does that mean? So if the monthly rent is $2,000, I'd recommend having the security deposit be $4,000 or $6,000. That's what I'd recommend. A lot of times, instead of doing first, last, and security, you could do first and a double security deposit, just in case if there's a problem, there's a large amount of money held in security, if anything is damaged and so forth, so that the owner is covered. But I've seen the security deposit be tripled, even quadrupled from time to time. It really just depends on what the owner is looking for and what they're comfortable with. It really just depends. It's at the sole discretion of the owner and you as the realtor what you're going to work out with. In my professional opinion, I'd recommend doing first, last, and a double security deposit. But you could do first and a double security deposit. For this particular example, let's say we're going to do first month's rent of $2,000, advance rent, which is counting for last month's rent of another $2,000, and a security deposit of $4,000, which is double the rent amount, just for safety. So we'll leave it there. If you have any questions, feel free to say something in the chat. Let me know if there's anything about what I'm discussing that you have questions about. I can further clarify. The next thing is the pet deposit. If there is a pet deposit, you'll click here. Is it refundable or is it non-refundable? In most situations, but not always, the pet deposit's usually non-refundable, and you can put that here. Let's say there's a $300 non-refundable pet fee. You put that there. If there is no pet fee, you don't check this. If it's refundable, you check the other box here, and it's refundable. Credit report fee. A lot of times landlords will request you as the realtor or broker to do a credit and background check on potential tenants. And a lot of times landlords may, tenants may have their background and credit check done prior. Maybe they have it, through Credit Karma or another company that does a background check and a credit check. Sometimes landlords, they don't want to accept anything from the outside. And this is completely normal and acceptable. And I kind of recommend it as well, because when you're dealing with the public, especially with other tenants, some people are honest and fair and they'll give you legitimate background checks and credit checks. But other times, some people try to falsify documents and so forth. So in that case, landlords may just request that, listen, I want you as the realtor to use a professional, reputable company that does credit checks and background checks, and I want all potential tenants to go through our background check. We need to do our own background check. We don't accept any from outside sources because we don't trust anything, for a possibility of documents being falsified. So you could do that, and that's where you would check this here. So there's a credit report fee, maybe, which can also stand for an application fee. And you could put that as, maybe it's like $50 you're doing a credit report fee, and you have I suggest using a reputable and legitimate credit background check company, or just a background check company. And then you could also do the other fees. Maybe you're doing a criminal background, eviction, and other types of checks, maybe sexual offender checks and so forth. You could put that here, and you could fill it in the other section here. So let's say criminal background check of another, whatever it costs, $50, $100. Don't get too crazy with this and try to charge someone $300 and so forth. Keep it reasonable and something that reflects the market of how much these things actually cost. I understand sometimes you may increase the fee for the labor of going through the background check and so forth, but I believe there's rules and laws that you can't charge ridiculous application fees and so forth. So charge something normal and so forth. But that could be written here if you're going to do a credit check, criminal background check, or other checks and so forth. There's another other section here for anything additional, maybe eviction check. Usually that's all included in a single background check. They do have good companies out there that will do everything, like an application questionnaire, criminal background, eviction check, credit check, basically an all-in-one package. And they usually cost around, it depends on the company. Some could cost $50, $75, $100. Just depends on the company. If there's an association, such as a condominium association or an HOA, and they require an application fee for tenants to lease a property in the premises, you'd put that here. Most of the time I've seen it's like a $100 application fee per applicant, but I have seen like $150, I've seen $75, $50. You just put that amount there, whatever the association is charging. So let's say the association is charging $100 per applicant. You put it there. Association approval is the next thing you could fill out. Application must be made when. Basically, this is stating that when you sign a lease contract, how long does the tenant have to make an application to the association? So you could put something here, like usually what I'll put is, I'll give somebody usually 72 business hours. Like 72 business hours to apply. You could write 3 days, 3 business days, 2 business days. I like to give 3 days. That's usually more than reasonable for someone to fill out an application to the association and submit it. But this is again at the discretion of the landlord and you as the realtor. So if you want to change that accordingly, go right ahead. This is just my professional, personal opinion. 72 business hours. The next paragraph, broker obligations. So you could read through this paragraph, but to keep it simple, you're basically going to be check marking these boxes that apply. So let's go through them one at a time and discuss them quickly. Display appropriate transaction signs, including a for rent sign on the property. If you're going to be putting a for rent sign on the property, or your sign of maybe your company logo and your information, you check mark this box. If you're not going to be doing any of that, don't check mark this box. However, if you are going to be putting a sign on the property, make sure this box is checked. You don't want to be doing that without this box checked to basically authorize and fulfill the obligation and so forth. I've seen many times where this box isn't checked and then someone puts a sign down later. It can cause problems, so make sure you check it if you're putting signs down. Use owner's name in connection with marketing or advertising the property. This is at your sole discretion as a realtor and also between your client, the landlord. I've seen in the listings on the MLS, there's like an area for you to put the owner's name. You could put the owner's name there in the MLS listing for it to be advertised with that. Most of the time I leave this box blank and I don't put the owner's name in the MLS listing, but if the owner's fine with that, you could check this box and put it in the MLS listing where it says owner's name. The owner's information, you know, if it's a company that owns the property or an individual or a trust, whatever it may be, like 95% of the time it's in the public records. So if you search the public records, you're going to see that information, so anyone really has access to that. But maybe the owner doesn't want you to put their name in the MLS, so I usually just leave this blank. I never put the owner's name in the MLS and so forth. Most realtors, they know where to search the owner's name in the public records when they're writing up a contract, and if they don't, they could always contact you and say, hi, listing agent, you know, they'll say to you that they're trying to write up a contract. Do you have the owner's name for them to put it in the contract? And the listing agent will provide that. So I usually leave this blank, keep it simple. Use a lockbox system to access and show the property. If you're putting a lockbox, a super onto the property, check mark this box. If you're not, and maybe the landlord's providing access, or the landlord's giving you a key and you're going to be personally showing the property, then you don't need to check this. But I usually always check this unless the landlord says otherwise. Most of the time there's a super and a lockbox on the property, but that's not always the case. You could be doing the showings personally, the landlord could be doing the showings, there could be a tenant in the property that's allowing access to do the showings, so it just depends. But if you're going to use a lockbox or a supra, check mark this. Next box, request a credit check on prospective tenants at owner's expense. Broker makes no representation as to the truth or falsity of information provided by the prospective tenant or as to the financial integrity or fitness and character of the prospective tenant. Well, what does this mean in simple terms? Basically, the owner is authorizing you, the broker, the realtor, to do a background check, a credit check on the tenant. So at the owner's expense, most of the time the tenant will pay for it. So let's say you have a prospective tenant that's interested in your listing. You let them know the owner wants you to pay for an application to check your credit. So you could usually have a lot of the third-party companies these days, they have like a link you could email to the tenant, and the tenant will access the link, make the payment through their credit or debit card, and then once the tenant submits that payment, the company will run a credit check on the tenant and so forth, background check, whatever is needed. And that's usually how it's done, but you could check this to let the owner know that it could be out of the owner's expense. But most of the time, it depends. You could check this, and if the owner's complaining, saying no, I want it to be at my expense, I'm not paying for other people's credit checks and so forth, then you could just leave this blank and just let the prospective tenants know that in order to put an application in, they need to do an application through the what your brokerage is recommending and the landlord's recommending that they, the company that you're planning to use to do these credit checks, and make sure it's, once again, a reputable and legitimate company. So, but most of the time I check this, and I just tell the owner that you're not going to pay for anything, you don't have to, and so forth. The tenant will, and usually they're fine and they'll proceed forward and trust my word. But because I'll never charge the owner the expense and so forth. But you can leave this blank if you want to. Most of the time I check it, because usually when I'm doing rentals, we're doing the background checks personally, and the credit checks, because that's what the owner usually requests, because they don't want to trust any other outside documentation. Execute leases on behalf of owner is the next paragraph here. I rarely see this particular box checked, and I recommend not doing it unless under very, very unique circumstances, because you need to have the owner grant the broker a special power of attorney. In fact, usually, because you're going to be executing documents on behalf of the owner, so they don't have to sign contracts, you sign it for them. Once again, if that applies, you check mark this box. We're going to skip over this. I would discuss with your broker before you start exercising those type of special powers of attorney. But you can do that. That is allowed. But I usually always like to have the owner sign the documents, unless, like I said, in a very unique circumstance, I want the landlord to sign on their own behalf, so they, there's no discrepancies. They signed and they reviewed everything before they signed. So we'll skip that. Compensate any subagents or cooperating brokers in a transaction, except when not in the owner's best interest. I always check this, because most of the time you're listing this property in the MLS, and you're going to you're going to need to share your commission most of the time, or a portion of your commission. If you're doing a rental, usually you're splitting the first month's rent. Not always. There's different types of commission splits. Every situation is unique, but let's say for this example, you're going to be like we said here up the top here, it's $2,000 a month for the rent. So you check mark this, and if another tenant's agent gets involved, they're representing the tenant, then you'll split that $2,000. You'll give them $1,000, and you'll receive $1,000 because you're splitting it in half. But I've seen listing agents offer only 40%, so they keep, the listing agent keeps 60%, and they give the other cooperating agent 40%. I've seen less than that. I've seen more than that. It really just depends on whatever the agreement is. But for this particular contract, let's say it's half the amount, and you're going to cooperate with the agents, except when not in the owner's best interests, because you should cooperate your fellow realtors if they're bringing a tenant that's going to be leasing the property. They would have never found that property without their realtor, so you should compensate that realtor. Simple enough. Always check mark this usually. The next thing is the withhold offers to lease property once owner enters into a binding lease agreement. I usually always check this. If I've executed a lease, I usually withhold anything extra, especially if I'm getting a lot of offers. If I need to take backup, I'll just keep everyone's information, and if things don't work out with the current lease, then I'll contact everyone else who sent me an email requesting, putting in their offer that didn't get accepted. But I like to withhold all offers, because once a lease is executed, then things are moving forward, and if anything changes, then I'll go back to the previous offer. So I check mark this. If you have any questions about this particular paragraph right here, then let me know. But I always check mark it. Make a final inspection and inventory check of property at conclusion of lease. This is at your sole discretion. Sometimes I check this if the landlord requests it, especially if there's a lot of inventory. Like I said, if it's a furnished unit and there's kitchen equipment, furniture, and so forth, you could check mark this. You could also leave it blank if it's a vacant unit and the landlord is not interested in doing a full inspection and so forth. But this is your sole discretion. We'll leave this one blank for right now. I always check the next one, complete lease forms as permitted by law, in case you need to use the lease contract, the one that all realtors, and the only ones that realtors are supposed to use for residential leases. You can fill in the blanks on that for your for the parties involved. I would check mark this. I've never seen it's not check marked, because usually what did the landlord hire you for? If you're not going to be completing some of the contracts for them to sign, they want you to fill in everything and advise them, and then all they have to do is sign. So check mark that. definitely check mark this. I never leave this one out. Well, that's not necessarily true, because it's signing on the owner's behalf. I usually I'm sorry, this one I usually leave blank because it's once again asking for you to sign on the owner's behalf. I always let the owner sign. But regardless of that, you can check mark this. Just if there's a lead paint disclosure, the property was built prior to 1978, always make the owner sign it. Once again, unless you have that special power of attorney up here, definitely make the owner sign it on their behalf so they know what they're signing and they signed it with their own hand, or with their own themselves pretty much if they're doing e-signature. But I'd recommend definitely completing it. I usually leave this blank, to be honest with you. I forgot about reading this, that it's on the owner's behalf. I don't like that's just my opinion. I don't like to sign anything for my clients. I like to let my client sign for themselves. Then there's the other. If there's anything additional that you're doing, you can write it here. If you're a part of our brokerage, contact me if you have anything additional that you're doing here or have questions about, or if you work for another company, talk to your broker if there's something other that you're going to put there, or whatever the case may be. But fairly simple. This is usually how I fill it out. Of course, you could change these as needed and how you're doing your contracts. You can make the final inspection, you could not. One thing definitely out of all this here is, be careful if you're going to be signing things on your client's behalf. I rarely see that done, but it does happen, and it is a thing. It can take place, and it is used in certain situations and can be helpful. But in my opinion, I always recommend that you have the owners and your clients sign on their own behalf. Don't sign for them or go that direction unless specific circumstances. The next page, and feel free to ask any questions if you see anything that you feel you would like to ask a question on throughout this tutorial. Advertising. This paragraph here, to be honest, I never fill it out. If you can't display the property address on the internet here, as we'll discuss, in my opinion, what's the point in marketing the property? If you're going to be taking a listing, you need to, in my opinion at least, you need to display the address online through the MLS and let it syndicate to all the major websites. So I never fill this out here. It's at your sole discretion of how you do your listing, but from my professional opinion and in our brokerage, we don't fill this out here. We usually always leave this blank. Advertise on the internet. The internet's your most powerful tool in today's day and age. So this is kind of obsolete, this paragraph. So if you really have questions about it, you can ask me. But my recommendation, just skip over this and move on to the next part, which is virtual office websites. This is at your sole discretion and the landlord if they request it. Most of the time, I skip this too, because it's nothing here that's really, in my opinion, anything that's like serious or really needs to be taken into consideration. It's just the automated estimate of the property, which is, you can read the paragraph here, which is basically like an estimate of the market value. Some websites offer this tool. And the other paragraph here is to third parties to write comments or reviews. I've never really seen comments or reviews written about a property or anything like that. So most of the time I just ignore this paragraph too. But this is one of the things where in our brokerage, if the agent clicks these or the landlord requests these, the seller, whatever the case may be, as long as it reflects on the MLS that these are turned off, it's not a big deal. It's not going to really, it's not like, not displaying the property address on the internet or not putting the property on the internet. This thing down here really doesn't matter either way, in my opinion, but it's at your sole discretion. The only thing I could advise is that if you're going to check these boxes, I've seen agents go put a listing in the MLS and they have these turned on. So you can't have a listing agreement that says no to these things and yes on your MLS listing. That's a liability issue. And that's that's not a good way to do business. That's basically telling your landlord we're not going to do this. And you go behind their back and do it because of your ignorance when making the listing. So keep that in mind if you're filling out your MLS listing and you're check marking these boxes. In my professional opinion, I just skip these part A, part B here. I just skip them unless requested otherwise by the landlords. So, moving on. That's the best thing to do, and the easiest thing is to just not worry about those unless the landlord is specifically requesting something or doesn't want something. Then you could discuss it and make a decision from there. Owner obligations, the next paragraph. Here it's pretty simple to fill in. To make property available for broker access during reasonable times and furnish broker with the following keys. So if there's a unit number, you put the unit number here, building access, mailbox keys, pool keys, garage door openers, anything other, maybe a building access card or something like that. You fill this out here. You know, how many keys, access cards, garage door openers, anything like that. Mailbox keys, you just fill that out here as accordingly. So let's say there's like one mailbox key, one pool key, one garage door opener, 2 keys, you know, one as a backup. Simple here. We won't spend too much time here. Moving on. This paragraph here is the next thing to fill out. To provide complete and accurate information to broker, including disclosing all known facts that materially affect the value of the property. See addendum. You know, you'd write whatever the addendum number is, entitled addendum 1, titled exhibit C. If the property is built in 1977 or earlier, you'd fill out a lead paint disclosure. In a lease contract, when you do a lease, there's a paragraph in there that discusses lead paint, so you don't really need to worry about this too much, this paragraph, because that's in the lease contract it's the only contract you're really allowed to fill out. I'm in the state of Florida, and there's a lead paint whole page there, so you'd fill out that page, and you're covered as far as the lead paint disclosure. But most of the time, you don't really need to fill this out here. I usually leave this blank, but you could fill it out here if there's a separate addendum that you want to use, or if there's something you know about the property. Let's say there's leaks on the property or something, then you could disclose it in a separate addendum and take it from there. So yeah, this particular paragraph, you basically write up a separate addendum if there's anything you need to disclose. Maybe there's some type of roofing issues or anything that affects the value of the property. You could write up a separate addendum for that. Maybe there's some type of landscaping issue or something, a little issue with the roof or something like that. Basically, if there's any type of thing that the seller knows about, you could write it up in a separate addendum, and then it's your job as the broker and realtor involved to disclose that to any potential tenants if there's any issues with the property. So we'll move on from there. We're not going to spend too much time discussing this. Important paragraph. This is how you get paid. So the next paragraph to discuss is compensation. Owner agrees to pay broker the following fees. You check mark which box applies. If you're getting a gross value of the lease, you check mark that here. If you're getting the percentages of the rent due in each rental period, you check that here. Most of the time, when I'm doing rentals personally, I check mark the third box here, which is 100% of the first month's rent. So like we saw in the contract earlier, the rent is $2,000 a month. So I usually request that the first month's rent is completely my commission, but it could be 50%, it could be 80%. It's whatever it may be. You could also check mark the other box down here and write a flat fee. Maybe your commission is $5,000. It just depends. So really, this is at your sole discretion on what your commission is going to be. Most of the time for rentals, this is what I put. Okay. So usually I do 100% of the first month's rent. The next part is the time and manner of payment. Broker will deduct its fee from rent collected by broker after said rent becomes due and owing to owner. Most of the time I check mark this. You could put a calendar day here. I usually do, so I don't leave anything blank. Maybe like 5 days, 3 days, something like that. Owner will pay broker's fee within, I usually put 1 day here. Most of the time, you as the realtor, you'll be collecting the, especially if you're the listing realtor, you'll be collecting the fees up front. So what you could do is you could basically have the fees collected right there. Give me 1 moment. I need to take a call, and I'll be right back with this tutorial. I'm back. Sorry about that. Sometimes you get business calls in the middle of the tutorial, but so we'll continue where we left off. We're talking about when the commission is due. So yeah, I wouldn't worry too much about this particular paragraph here, because most of the time when you're a listing agent, you're going to be collecting all the fees on the day of moving. Most of the time you'll have the check split up that all the money going to the landlord goes toward the landlord when the tenant moves in, and you don't usually let the tenant move in until they have the commission check written out to your brokerage. Usually don't make if there's a cooperating realtor, their other check made out to the cooperating realtor, or you could write the full amount to, usually I guess the proper way, to give you the proper way it's done, is the full commission amount is written out to the the broker, the listing broker, and then the listing broker will pay the cooperating broker. So if your rent is the first month's rent, $2,000, the tenant should be paying you, your brokerage, a check of $2,000 on the day that they move in, and then the rest of the fees paid directly to the landlord, so that your brokerage receives the $2,000. And if you're splitting that with the cooperating broker, your broker will split that and pay the cooperating brokerage. So usually I check mark these boxes. Usually it's the second one. Broker will pay the fee within 1 day after entering into a lease on the property. So just to keep this simple, check mark this middle one. 1 day you're going to get your fees, because it really shouldn't be waiting any longer. You should be receiving it the day the tenant moves into the property. You should be the one collecting the checks. But if that doesn't pertain to your deal, you check mark the other boxes accordingly. So you go from there. Protection period is the next paragraph we're going to be discussing. I just put like 90 days here just to keep it simple. You can read through this paragraph if you'd like. It's basically just your compensation's due if this lease expires, or this contract expires, or gets canceled, or whatever the case may be, and a tenant that you showed the property to ends up leasing the property, you're still due your compensation. So don't leave this blank. It's not recommended. Usually put 90 days personally, but you could put 30 days, 45 days, it's up to you. Now, the compensation with other brokers, this is if another realtor gets involved and brings a tenant and you're going to be splitting your commission. So I usually offer, so you could write it of the gross value of the lease, a percentage of the first month's rent, or a flat fee to the tenant's agent. It just depends. Most of the time, I usually put, if it's you're getting 100% of the first month's rent, you put 50%. You usually give them. This could be different. You could offer only 40%. It just depends. Me personally, I usually offer 50%, but that's, it could be changed accordingly of whatever you're offering a cooperating realtor. So that changes depending. So you'd fill that part out. And then usually I check mark the next paragraph. These are just discussing the relationship types. I'll just put in the 50% for each relationship type. So this is for the no brokerage relationship, the transaction broker relationship. The next one here is the check mark this. This is for transaction brokers. This third one's for transaction brokers. 50% first months. So you could miss a lot of things in this paragraph. So I'd recommend, use our tutorial if you need to, or definitely just be careful what you're reading through this. You want to offer compensation to all the relationship types. Me personally, I keep the amount the same for every single relationship, because it doesn't matter to me what type of relationship they have with their client. I only care about if they bring a client that's able to rent the property and close this deal. That's all I care about. I pay everyone the same, but if you're going to offer different amounts of different relationship types, you can. So to keep this very simple, I just check mark these three boxes. You never check mark the bottom box, because then you can't put the property in the MLS, and there's no point in taking a listing, in my opinion, if that's the case. So you just check mark these three boxes, and you write the percentage accordingly. In my situation, an example in this video, it's 50% of the first month's rent. So we're writing 50% for all the relationship types. That's it. The first three boxes, 50%, then just read the sentence after that, of the first month's rent. Same thing with down here, 50% of the first month's rent. But if it's of the gross value of the lease, you write it here. And if it's something different like a flat fee, you write it there. But we're leaving those blank because it's 50% of the first month's rent. Early termination. This if the owner, maybe been advertising for 2 months and the owner decides they don't want to lease anymore. They don't want to rent the property. They just want to take it off the market. This paragraph is for, if you had, like, say, a lease contract, 4 months went by, now the owner says, I don't want to rent anymore, just pull it off the market. I want to cancel our listing agreement. I don't want to do anything anymore. Your time went into the property, and time is money, so your time and money was wasted in advertising this property. So here's usually where I would write the cancellation fee, because if you're not going to be renting the property, you can't advertise it no more, you can't earn a commission. You should be compensated for your time spent in advertising the listing, creating the MLS listing, possibly visiting the property, returning keys, showing the property to the tenants. You invested time and money driving to the property, wherever the case may be. So I always put something here. I've seen realtors put 0 here. That's up to you. Me personally, if I'm working with a client, I do some type of cancellation fee. If they want to cancel the listing, I'm not going to hold them to the listing and say, no, I'm not canceling nothing. I'm holding the listing for the next year. And we're just going to have to advertise it. I don't recommend doing business like that. That's just not good business. But I do request a cancellation fee. How much you request is up to you, and depending on the size of the lease and how much work you put in. Me personally, I always put like $500, $1,000, $850. It just depends, and it's at your sole discretion. I usually recommend to put something there if they're going to cancel the contract on you, because your time should be respected, because everyone works for a living, and you usually put in quite a bit of work to advertising the property. And if they're just going to cancel the contract on you like that, you should do something for the cancellation. The next paragraph, arbitration. I always recommend having the owner's initial here, and you initial here as the listing associate, and the broker initial. You could read through this paragraph for further information. I'm not going to sit here and read it to you, but I always recommend you initial this paragraph. It's pretty important for liability reasons and just the whole dispute resolution process if there ever is a problem. So feel free to read through this, and you could talk to your broker for further clarification on this, but just in my professional opinion, I never do contracts without it. I always make everyone sign this here. Brokerage relationship. The preferred relationship, and what I always recommend, is to operate as a transaction broker. It's just so much easier. The liability of single agency is just it's unnecessary in my opinion, unless under very unique circumstances. So we'll keep this part here simple. We're almost at the end of this tutorial. The transaction broker you put here, and keep it simple from there. Just check mark transaction broker. If you're going to be doing a single agency, if you're part of our brokerage, reach out to me and let me see why you feel the need to do single agent. But if not, then you're part of another company. Just that's between you and your broker. But for our company, I highly recommend using transaction broker. It's not required, but if you do feel the need to do single agent, contact me first. But let's keep it simple and move on. Transaction broker is the standard and simple relationship. And that's pretty much it for the contract here. You have the additional clauses section here. I usually never fill this out here unless there's some type of unique circumstance, but for the most part, that's the end of this exclusive right to lease. The only thing is down here at the bottom, you of course have the owner's date and sign. You can fill out this information as required. I usually always at least put their email address down here for communication purposes. Authorized associate or broker. If you're a listing agent, you sign here, you date it. You can put your email here. And then I always recommend, this gets left blank a lot of the time. I don't recommend it. It's not that hard to just check mark by email. Usually, if you're doing e-signature, that's most of the time most contracts are signed. At least in my experience, it's usually signed by email, e-sign. So you just put the date here when it was e-signed, and you can just stamp the date there when you do the e-signature with whatever program you're using. But a lot of times this gets left blank. Don't leave it blank. I recommend filling it in. It's the right way to do it. Other than that, you have the initials on every page. Make sure everyone initials on each and every page. Of course, there's the signatures at the end. And that is the tutorial for the exclusive right to lease listing agreement. This is one of the more popular agreements. I've got a lot of questions about it, and hopefully this extra tutorial going through it answered some maybe additional questions about certain paragraphs, about how to handle this particular contract. But yeah, hopefully it was helpful. I'm going to be doing more live streams going over different contracts in the future, so feel free to leave a comment. Stay tuned for the next one. For right now, I'm going to have to end this particular live stream, but I plan to do a lot more tutorials and a lot more just going over contracts, maybe giving advice and doing other various real estate things to help out with anyone who may be interested in our content and the content I'm putting up. And that's it from there. Other than that, our company is Nizz Realty Inc. We're licensed in the state of Florida, hopefully other states in the coming year. But right now it's just the state of Florida. We pay all of our agents 100% of your real estate commission. The way that works is in the description of our YouTube channel and on our website, nizzrealty.com. If you want further information, you can feel free to give me a call. My number is on our website, nizzrealty.com, and more information about that's in the YouTube About section in the description in all of our videos. So this is our first live stream. I hope everyone enjoyed it, whoever did tune in and see it here, if anyone is here. And we'll see you in the next one. Thank you very much, and you have a good rest of your day.